This case is a perfect example of how silence in court can cost you everything. A business owner with over 50 years of operations is now facing a lawsuit that's been dragging on since 2020. But here's the twist. While the plaintiffs claim they've been trying to reach him for years, he says he thought the case was already resolved. No lawyer, no responses. And now, he's standing alone in court as a judge prepares to make a decision that could financially destroy him. The question is, did he misunderstand the system or completely ignore it?
And we've been done business for 53 years.
Right, but who are you in the company?
I was the president. I'm the owner.
Okay. So what I have us here on is a request for a default and a motion to dismiss counterclaims. The allegations are, despite quite some time with this case being involved, it's been difficult to get any response from you. So I'm going to hear from Ms. Meyer or Ms. Kohara, and then I'll hear from you. Go ahead.
Okay. This case.
No, not you, sir. We're going to hear from the plaintiffs first and then from you.
Okay.
Your Honor, as this is Mara here. As you know, we have been trying since 2020 to get with Mr. Samarex through his counsel, and in fact, we moved to strike the trial date because we never got a response, and his counsel withdrew from representation. We thought there was new counsel that was going to represent him, and they told us they were not. I don't know if he has counsel on this call that is representing him or if he's representing himself, but our point was, twofold. Again, this was filed in 2020. We moved to strike the trial date. When we spoke with you then, we had indicated we'd be filing a motion for default and that we'd also be filing to dismiss the counterclaims. I know my co-counsel, Ms. Meyer's office, had served by email, and she can go into that further if you need her to, Mr. Samarakis and his company, and we've heard no word, and frankly are surprised she's on this call today. And, we had to take a lot of time and efforts to put the motions together and have, struck the one trial date we had. We had spent countless time trying to reach out to folks we thought were representing him, only to be told that he was not. And so we're here to move right now to dismiss the counterclaims. They have not been prosecuted at all. And then we also move for a default judgment because, again, we've been trying, and this is 5 years. And I don't really know what else we can say other than, you've got the affidavits from Ms. Meyer and the support for what is owed. And again, we had no indication that anyone from Mr. Samarakis Incorporated was going to be here today. They never reached out to us.
Ms. Meyer, did you have anything you wanted to add?
No, I concur with what Ms. Kohara said. Additionally, it's my understanding that
this is one of the most important legal moments in the entire case. The judge makes it crystal clear, even though he's the owner and former president, he cannot legally represent his own corporation in this court. That's a rule many people don't realize. Corporations are treated as separate legal entities, and they must have licensed attorneys to speak on their behalf. So even if everything he's saying is true, it doesn't legally count here. At this point, he's effectively present, but powerless to defend his company.
Court, with some small exceptions, like small claims court or perhaps tax court. That is not where we find ourselves. So I will let you tell me what you believe is going on right now, but without an attorney here, nothing you say is going to be deemed a legal argument on your corporation's behalf.
Okay.
So what would you like me to know?
Okay. What I want you to know, Georgia Pacific, I've been doing business with him for 45 years. Never had any problem with him. And on the last job we had, It was a machine. It's going to Palatka, Florida.
Well, hold on. So you're getting into the merits of the case.
Okay.
Which is what a lawyer would do. So really, what I'm asking you is, do you have a lawyer?
No, I had a lawyer, Matt Anderson from Longview.
Okay.
He's handled this for a long time, and he stopped because I don't know why. We had on that job $1.9 million in, and they canceled, the Georgia Pacific canceled the order and bought Chinese pumps because they were cheaper. The reason for me to be here today is to give me time to find a lawyer, because all this paperwork I got from the lawyers from Georgia Pacific, they mail it to me in my home in March 28th, and I had a court date April 2nd, and then they changed it again to the 23rd today. I had no time to find a new lawyer, so I need permission from you from the court to give me time to find a counsel so they can represent me legally. I have all the files. Like I said, I done business for 45 years. They have over 250 of my pumps on the systems. And after they canceled my order and I had all my money in it, the pandemic hit and I went out of business because of that. So I do want it to have a counsel to tell the whole story. I have receipts, I have purchase orders, I have agreements, I have everything. And now they tell me I have to pay them back. For what? I have my own money, $1.9 million into it, and I went out of business because of that.
So you filed your counterclaims June 15 of 2020.
Here's where the emotional weight really hits. He's asking for just a few more weeks to find a lawyer, claiming he didn't have enough notice and believed the case was going away. But the judge focuses on one key issue. This case has been active for 5 years. From the court perspective, that's more than enough time to act. And this highlights a brutal reality in civil cases. Delays, assumptions, or relying on past conversations can cost you everything if you don't follow through properly.
Everything if you pay them $12,000. And I told...
I'm going to pause. I don't have that attorney here, and I don't have that in a declaration in front of me.
He used to be my attorney.
I understand. So I think what I hear you saying is you believed this was going to go away.
That's what he said is going to go away. My question to you is, Your Honor, it's any way I can have 4 to 6 weeks to find a new counsel.
No, I believe you've had sufficient time if you wanted to pursue this to move forward. In all frankness, statute of limitations on all or some of your claims probably has run at this point. So I am going to go ahead and sign the order for default for failing to defend. I am going to dismiss your counterclaims with prejudice. I am going to sign the order presented for the judgment.
So explain it to me, because my language, English language is my second language. I'm Greek. What am I supposed to pay Georgia Pacific now?
There is a judge, what I can tell you, and I can't give you legal.
And just like that, it's over. The judge grants a default judgment of $1.2 million against him and dismisses his counterclaims permanently. That means he doesn't just lose the case, he loses the right to argue his side entirely. This wasn't about proving who was right or wrong. It was about failure to defend the case properly. So what do you think? Was this a harsh outcome or a predictable one given a lack of legal action? If this case shocked you, hit like, drop your thought below, and subscribe for more real courtroom breakdowns.
Whatever you feel you need to do. I can't give you legal advice, but I will remind you that as an corporation, an incorporated corporation, you cannot represent yourself in court. Okay?
Yes.
All right. I've gone ahead and signed that order, and I'll hand it up to the clerk. Anything else we need to do today?
Thank you, Your Honor.
Okay, thank you. Number 3.